In an adoption proceeding from an authorized agency, if the child is less than 18, the child must have resided with the adoptive parents at least 3 months before the order of adoption is made. To conduct pre-placement investigation.
Yeah, so it's a social worker, the probation service, or the authorized agency designated by court.
Right.
Okay.
Okay. An order granting certification is valid for a maximum of blank month. This is an order. The order granted.
The order granting, is this the 18 months?
No. Yes, sorry.
Okay.
Yes, 18 months. Okay. Next. Generally, a conditional order of certification, so the conditional order is valid until replaced by an order of certification or by an order denying the petition, whichever occurs first, but in no event is longer than blank days from the date of the original issuance. Now,
okay, so I remember this because the regular order is 18 months, and then the conditional order, you take the 1 and the 8 and put a 0 next to it, and then it's 180 days. So it's 18 months and then 180 days.
Yes, perfect. Okay. Provisions regarding certification do not apply to step-parent where the child has resided with the step-parent and birth parent for a continuous period of at least...
Is it 3 years?
1 year.
Fuck!
Yeah, 1.
Okay, so step-parent, it's only 1 year.
Yeah, is this like when they lose, it's like the parents aren't around for like a year or 15 out of the 22 months? Is that why it's like saying that? It's 1 year?
I don't know. I didn't know that it was 1 year. I don't even remember, like we did it 5 minutes ago. I already forgot it.
Fuck. Because termination of parental rights, they have to like not have contact with 1 year or 15 out of 22 months. So I was just thinking that.
Oh, I don't know. All right, so this one is, so as the step parent, it doesn't apply if they've been living with the step parent for 1 year.
Yeah.
And this is different than the pre-adopted parents under 18 resides with the adopted parents for more than 3 months.
Yes.
There's no waiting period, so that's different than this.
Yes.
Okay.
Okay, and the last one. Generally, a written investigation report shall be submitted to the judge or surrogate within
30 days.
Yes, 30 days.
30 days of what, though?
After it's ordered.
Okay, so they have 30 days to do the investigation and report on it.
Yes.
Okay.
Okay. All right.
Is that it?
So wait. Yeah, that's it for the multiple. I mean, I have multiple choice, but I just have a question.
Yeah.
For an order with civil, a regular order has to be done within 60 days, right?
Yeah.
Decision?
Yeah.
The provisional is 20 days.
Yes.
And then here, the investigation report, the order has to be done within 30 days?
Yes. And then also in civil, if it's relating to child support or support, like in like a matrimonial or whatever, it's 30 days.
Okay. And then what about something with the medical, dental, and whatever?
Oh my God, there's so many time rules on that. But Angela and I have like mostly her, has a really good series on it. There's a 45-day rule for, there's like 3 different things. There's a 45 days for the mandatory settlement conference. Then there's the 60 days for the filing of the, some other conference. And then there's the certificate of merit has to be filed within 90 days after the plaintiff gets the records from the doctor they're suing. They have to file the certificate of merit. Then there's 60 days for filing the notice of med mal. And then there's a 45 days for the conference.
Fuck, all right. And then with the foreclosure, it's 60 days, right?
Yeah, the foreclosure at 60 days.
For what? 60 days
For the settlement conference.
the settlement conference. Okay, all right. I don't know why that just came up. Sorry.
No, it's fine. It's the only reason I know those ones about the med mal is because she has it on the video.
Fuck, I know. I think I remember hearing it, but I don't remember it. I'm gonna fail. I can't remember any of this.
You're
shit.
not gonna fail. Don't worry.
Ready?
Go.
Okay. A support order or income withholding order from another state is registered here by sending the following documents to the tribunal here, with the exception of which one? A letter of transmittal sent here requesting registration and enforcement.
True.
3 copies included 1 certified of all orders to be registered.
False. It's 2 copies, at least 1 certified. Right?
Yes, and 3 copies of the petition.
The petition, right? Yes.
Yeah. So the support order, the income withholding order, and then the custody order in Article 5 are all 2 copies, 1 certified.
And the petition that New York sends to Oregon is 3 copies.
Yes. Okay. A sworn statement by the party seeking registration.
That the order has not been like vacated or modified or something?
Yes.
Okay.
The name, address, and social security number of the obligor.
True.
Yes.
Because I remember you were like, who wants to give their social security number?
I was just thinking that. I'm like, because nobody likes to do that anymore.
Right.
A description and location of obligor's property not exempt from execution.
At this part, you're like, go look at Article 52.
Yeah, and I was like, yeah, well, good luck. Go look into CPLR for that one.
That's true.
Okay, yeah. So the only one that was wrong was the copies. Oh my god, I'm like losing my mind. All right. I'm
getting so tired today.
I know.
Ugh.
I can't. In which of the following proceedings must an attorney for the child be appointed if no other counsel is representing the minor? Article 3, JD?
Yes.
Article 7, PINS?
Yes.
Article 10, Child Protective?
Yeah.
Article 5, Paternity?
No.
No, it's only 3, 5, and 10. I mean...
3, 7, 10. 3, 7, 10.
Okay. All right. True or false? Oh, okay, forget it. This is another stupid question. Okay. Okay, next quiz. Let's see what it is. It's like on everything, so let's see what this one is. I don't know if it's family court. Let's see what it is.
I don't care what it is.
Oh my God! This is on the DRL and the RPAPL and rules.
Cool. One? Yeah, let's do it.
Okay. A notice of appearance is to be filed at the first appearance in court or within blank days. Blank from retainer or appointment, whichever is sooner.
10 days.
Yes. There are blank terms of court, and each term is blank weeks long.
Okay, you can answer that one because I hate this question.
Okay.
I mean, if you work in a courthouse, you know that it's 13 in a year and 4 weeks. Like.
I know. Exactly. A county clerk, chief clerk of Supreme Court, or county court shall refuse to accept for filing papers under which of the following circumstances? 1, the paper does not have an index number.
That's true.
2, the caption of the summons, complaint, petition, or judgment has et al. Instead of naming all the parties.
Summons,
that's true, right?
Petition, or yeah, that's true.
Yeah. Those are the only ones that have to have all the names listed.
Right, it's like the answer and stuff could have just et al.
Okay. The paper is filed in the wrong court.
Yeah.
The paper is not signed in accordance with Rule 130-1.1 certification.
True.
The paper sought to be filed as an action subject to electronic filing.
I think that's... Oh, wait, subject... I don't know. I don't know if that's enough information to make it wrong.
I know. Let's see the answer.
Because if it's a pro se party, then he's exempt.
I know. It doesn't say that.
All right, so what else do they got?
That's it. It's saying that they're all true.
Okay. Well, generally, yeah, but if it's a pro se party, all right.
Okay. Or I remember your video because you're like, or if the
Luddite, he can't fucking figure it out.
You were like, oh, if he's too stupid to figure it out.
Do you know what's sad? Is that video? That was like the first video I think I ever did for this test, and that video has more views than any of my other videos, and it's horrible. It's so unedited. It's horrible.
And the one that you were doing the rain, you were like walking around, you're like, fucking Nate wants to.
Oh my god, that's my second most viewed video. Like
4 fucking months.
Oh my god, yes. Oh my god, yeah.
I was like,
I'm thinking about like how much effort it's gonna take to delete all these videos, and I'm like, you know what? I'm just gonna fucking leave them up. I don't care.
5, a calendar that is for actions that have had a pretrial conference or where such conference was dispensed with by the court, but where the actions have not yet been transferred to a ready calendar is known as a... Is that reserve calendar? I don't even know.
I don't.
Yes, it's a reserve calendar.
Okay, reserve okay.
Okay. Which of the following is an incorrect prefix for family court? Oh, we don't need this. Do you want to do it anyway?
Incorrect prefix for... We don't need no. I don't want to know. Anything that I don't have to know, I don't want to know.
Okay. Notice of permanency hearing shall be made upon the respondent or foster parents caring for the child or pre-adopted parents by the petitioner not less than... It's in a rule. It's a rule.
Oh, 205?
It's a 205 rule. Notice of permanency hearing shall be made upon the respondent or foster parents caring for the child or pre-adopted parent by the petitioner not less than 14 days. The following civil cases are entitled to a preference in regard to the order with which cases are tried. An action brought by or against the state.
Absolutely.
An action where a preference is provided by statute. An action where the interest of justice will be provided by an early trial. Action upon the application of a party who has reached the age of 70.
Yes.
An action based on medical, dental, podiatric malpractice.
Yes.
An action to recover damages for personal injuries where the plaintiff is terminally ill and alleges such illness is a result of action by the defendant.
That's also true.